A very good morning to all the honorable dignitaries, special invitees, resource persons, participants, honorable guests who are watching this program through YouTube channel of the Honorable High Court, ladies and gentlemen. A child is a beam of sunlight from the infinite to eternal, with possibilities of virtue and vice, but as yet unstained. Honorable Juvenile Justice Committee, High Court at Calcutta, in collaboration with Department of Women and Child Development and Social Welfare, Government of West Bengal and UNICEF, is going to conduct a state-level multi-stakeholder consultation on child in conflict with law. It is our great pleasure and privilege that to grace this occasion, we have with us the Honorable the Chief Justice T.S. Sivanganam, Patron-in-Chief, Juvenile Justice Committee, High Court at Calcutta. We have with us Honorable Mr. Justice I.P. Mukherjee, Chairperson, Honorable Juvenile Justice Committee and Executive Chairperson, State Legal Services Authorities, Government of West Bengal. We have with us Honorable Mr. Justice Harish Tandon, Member, Honorable Juvenile Justice Committee. We are grateful to the other honorable judges, High Court at Calcutta, who are present here to grace this auspicious occasion. It is our great pleasure that Mr. Muhammad Mahiuddin, Chief UNICEF Office for West Bengal, is present with us. Mrs. Nandini Paliwal, Commissioner cum Principal Secretary, Department of Social Welfare, Andaman and Nicobar Islands, has joined with us through virtual mode. We are happy to mention that Honorable Justice Mousumi Bhattacharya, Member, Juvenile Justice Committee, is on transit from Jalpaiguri Circuit Bench, and her ladyship will directly come here from Kolkata Airport to join with us during valedictory session of this program. May I now request Srimati Choitali Chatterjee Das, Registrar General, High Court at Calcutta, to escort the Honorable the Chief Justice to the dais. May I now request Srimati Chandrani Mukherjee Banerjee, Registrar Original Side, High Court at Calcutta, to escort Honorable Mr. Justice I.P. Mukherjee to the dais. May I now request Srimati Nabonita Rai, Registrar Admin 1, High Court at Calcutta, to escort Honorable Mr. Justice Harish Tandon to the dais. May I now request Srimati Paromita Niyogi, Child Protection Specialist, UNICEF, to escort Mr. Muhammad Mahiuddin, Chief UNICEF Office for West Bengal, to the dais. Now, we have the honor and opportunity to felicitate our honorable dignitaries on dais with some potted plant and painting drawn by the children of different childcare institutions of West Bengal. We have 4 children of Sukanya home running by Government of West Bengal. At first, I would like to call upon Anita, a student of class 10, children of Sukanya home, to come forward and to felicitate our Honorable the Chief Justice. We have some return gift for Ronita. I would like to now I would like to call Mishti, a student of class 10, children of Sukunna Home, to felicitate our Honorable Justice I.P. Mukherjee. Yes. Now I would like to call upon Sonamoni, a student of class 11, children of Sukunna Home, to felicitate Honorable Justice Harish Tandon. I would like to call Neha, a student of class 10, children of Sukunna Home, to felicitate Mr. Muhammad Mahiuddin, Chief UNICEF Office for West Bengal. May I now humbly request the Honorable the Chief Justice and other dignitaries on dais to light the inaugural lamp. Now, it is the time to release a book designed by UNICEF relating to frequently asked questions about the implementation of the principle of diversion as laid down in the Juvenile Justice, Care and Protection of Children Act 2015. May I now humbly request the Honorable the Chief Justice and other dignitaries on dais to unpack the book and release it. The digital copy of this book will be given to all the participants by the UNICEF. May I now humbly request Honorable Mr. Justice I.P. Mukherjee, Chairperson, Juvenile Justice Committee, and Executive Chairperson, State Legal Services Authorities, Government of West Bengal, to deliver welcome address.
From there. My Lord the Chief Justice and my brothers and sisters on the bench, Mr. Mohiuddin, Chief of UNICEF here, all the dignitaries here, members of the registry, the officers and staff of this academy, and ladies and gentlemen. Article 15 of our Constitution provides for protection of children. This is supplemented by the directive principles of state policy in Articles 39EF and Articles 45 and 47, which say that all the needs of children have to be met. Children are flowers which we nurture in our own garden, but sometimes we fail to take adequate care of them. They are too young to take care of themselves. In this perspective, the United Nations Convention was held for the recognition of rights of children and for protection of their rights. This was adopted by us, that is India, on 11th of December 1992. Some 8 years later, the Juvenile Justice, Care and Protection Act was enacted by Parliament. It was amended twice in 2006 and 2011. It was found that the protection which children were receiving under the Act was not at all adequate. The functionaries under the Act were not acting responsibly or were not aware of their full responsibilities. There was abuse of children within homes, in prisons, increased crimes by children between 16 and 18 years of age, delayed adoption process, and many other ways in which the Act was not working, as a result of which it was completely repealed and re-enacted in 2015. Now, this Act has broadly 3 spheres of action. The first is the one which takes care of a child who is accused, protection of his or her rights. The second is contain measures which dehouse litigation, legal action, etc. Outside the field of litigation, the society or the authorities have to take care of the child. And the third is for punishment of all those who are committing crimes against children, namely, it penalizes offenses against child sale, begging, cruelty, exploiting a child employee, kidnapping, etc. These are the three spheres of action of this 2015 Act. Now, this is kind of a run-up exercise which we have done, and that is why we are here to prepare ourselves for the final for the final deliberation or symposium on the rights of juvenile, which is to be held in Delhi in the following month. This is state level interaction. Consultation process we have just concluded, and and after conclusion of the state level consultation process on all these three spheres of action in which the Act is to function, and which will be the subject matter of discussion and deliberations in Delhi, we have assembled here to take stock of the situation and make us ready for the future, not only for the convention which is to be held in Delhi, and also to make us ready for our future course of action. Thank you very much.
Thank you, Lordship, for the valuable suggestion and enlightening us on different aspects of implementation of JJ Act. We are grateful. May I now humbly request the Honorable the Chief Justice T.S. Sivagayanam to deliver a keynote address.
Honorable Justice I.P. Mukherjee, the Chairperson of the Juvenile Justice Committee, Mr. Harish Tandon, Justice Harish Tandon, the member of the committee, and the other honorable members of the committee, my brother and sister judges who have assembled here, Registrar General and other registrars, the principal secretaries of the Government of West Bengal and that of the Andaman and Nicobar Islands, the Chief of UNICEF Office, West Bengal, the other resource persons, the rapporteurs who have assembled here, the learned Registrar General, other registrars, the district judges, the special court judges, the principal magistrates, the officials of UNICEF, members of the press and media, the director of the Judicial Academy, the additional director and officers, the secretary, member secretary of the State Legal Services Authority, the secretary of the Juvenile Justice Committee, ladies and gentlemen, good morning. At the outset, I convey my heartiest congratulations to the honorable members of the Juvenile Justice Committee of the High Court at Calcutta in organizing this state-level meet in collaboration with the Department of Women and Child Development and Social Welfare, State of West Bengal, and UNICEF. The theme of the state-level consultation is child in conflict with law. Every child has an inherent potential to grow up and achieve his or her full potential and contribute towards the growth of our country and society. The Juvenile Justice Act takes a holistic approach towards protecting the rights of children and providing for proper care, protection, development, treatment, and social reintegration of children in difficult circumstances by adopting a child-friendly approach. Children are both innocent. However, due to multiple reasons, many children adopt behaviors which are defined as delinquent and sometimes being in conflict with the law. The juvenile justice system assumes that a child offender is a product of unfavorable environment and is entitled to a fresh chance to begin his or her life. The child lacks foresight on the consequences of his or her actions. Delinquency exhibits a variety of styles of conduct or form of behavior. Each of the pattern has its own social context, the cause that being about it, and the form of prevention or treatment most often suggests as appropriate for the pattern in question. Howard Becker has referred to 4 types of delinquencies. The first of these is individual delinquency, group-supported delinquency, organized delinquency, and situational delinquency. The question would thus be as to what is to be done. Law enforcement agencies, parents, teachers, the schools, the community need to understand and prevent and reduce risk factors which may push children towards adopting behaviors that may harm them and the wider society and are defined as being conflict in law. There is enough evidence to prove that the right method of prevention and rehabilitation by adopting, the right method of adopting prevention and rehabilitation, most of the children adjust, reform, and return to the maturity of adulthood. Thus, it has become important to identify risk factors. Precisely for this reason, this state-level, multi-level stakeholders consultation has been organized. As pointed out by Honorable Justice I.P. Mukherjee, this event is a precursor to the forthcoming national meet, which is to be held at Delhi. Before this state-level meet, there has been discussion among the other judges who handle these matters on a day-to-day basis. And primarily for such reason, the principal magistrates have been invited to join this consultation today. And in the forthcoming business sessions, you have been divided into 4 groups, and the topics have been very carefully chosen. I think must be the brainchild of Justice Tandon. And I request all the participants to make full use of the business session. Of course, this inaugural session is only a formality, so we'll make it as short as possible. The discussions which you are going to have in 4 breakaway groups is the core of the entire state-level consultation. And when you all come back and reassemble after the discussion, you give your ideas, you make your presentation, and with that, the Juvenile Justice Committee will prepare a vision document or a presentation which will be placed in the national meet to be held. I'm very happy to inform that the Juvenile Justice Committee of the High Court has been very active, proactive, and vibrant. More than 1,000 books have been distributed, and the committee has been periodically reviewing the progress of setting up of exclusive POCSO courts. And as of now, 3 courts are functioning and 13 courts are in the pipeline. Probably we'll be able to make them functional as early as possible with the assistance of the government of West Bengal. Apart from that, the committee has been constantly monitoring the various children's homes. And today you have seen these 4 beautiful children who were here, and we were all gifted to be presented with the beautiful artwork done by them. And it is really heartening to note that the Juvenile Justice Committee does a lot of hand-holding to ensure that these homes are being maintained and monitored in a proper manner. Apart from that, the district judiciary submits their monthly report with regard to the POCSO and adoption cases before the committee, and the committee reviews the situation. Because in certain jurisdictions, especially in South 24 Parganas at Alipur, the number of adoption cases, I think, is the highest among in the state. And this is being constantly monitored by the committee. Apart from that, the committee members, in fact, very recently, Justice Tandon has visited the homes to just review the condition. It is not with a view to, monitor may be right, to act like a principal or a headmaster going and visiting the homes, because the government should accept that the Juvenile Justice Committee is part of the system. It is by operation of law that we are part of the system, and whatever suggestions, ideas which flows from the committee needs to be appreciated, taken note of by the government, and implemented at the earliest possible time. I would also like to mention that the government of West Bengal has been proactive on very many suggestions which have been given by the Juvenile Justice Committee through the High Court at Calcutta. And recently, the Principal Secretary of the Public Works Department has submitted an estimate for construction of the exclusive POCSO courts, which is under the consideration of the committee to be approved shortly. And apart from that, there is a vision document which has been prepared by the committee as to how the committee is going to function in the near future. And I find the vision document to be thoroughly exhaustive. They have set several goals, and I'm sure and I'm confident with the support of all of you and other stakeholders, the committee will be able to fulfill the vision which they have drafted for themselves. UNICEF has partnered with the High Court, has been consistently partnering with the High Court. And the role of UNICEF is very important because they are the persons who will place before us the global scenario, what happens throughout the world. How can we better our systems? How can we better equip ourselves? How the judiciary can step up and fill in the gaps which are now being felt in the process of implementing the provisions of the Juvenile Justice Care and Protection Act. Apart from that, regular training programs are also organized by the Academy for judges who handle such courts. And in fact, the Honorable CJI has always been batting for domain experts. So he says, because now we have set up commercial courts. We are setting up special courts for POCSO, special courts to try offenses for the members of the Legislative Assembly and the members of the Parliament, etc. CBA cases, etc. There are a lot of special courts coming in, new enactments. So once you get a special court, the judges need to be trained in that particular branch of law so that they'll be better enabled to handle the subjects which come before them. In fact, the Commercial Courts Act, the underlying principle is there will be a separate chain of judges who will get qualified and selected in a commercial court, and they will climb the ladder probably to the High Court in the Commercial Division, Appellate Division, and then to the Supreme Court. So therefore, all of you who are principal magistrates here are considered as special judges or specialist judges. So therefore, I request each one of you to play a very vibrant role in the interactive session and place your opinions so that it can be placed before the committee. And when we wind up today for the day, we'll carry home very many ideas which we will present in the National Convention. I'm also happy to state, as mentioned, that the Government of West Bengal has sanctioned substantial funds for construction of exclusive POCSO courts in West Bengal. the highest being at 2.41 crores for the district of Uttar Dinajpur, followed by 36 lakhs for Murshidabad and 2.81 lakhs for Cooch Behar and 1.18 lakhs for Birbhum. As I said earlier, with the cooperation of the government, our endeavors will be successful. And once again, I congratulate the Juvenile Justice Committee, the team of officers who have put their minds together and chosen very wonderful topics. The 4 breakaway sessions are going to be really interesting. So I wish all of you a good interaction and come back with very vibrant ideas. Thank you very much for this opportunity. Namaste.
Thank you, my Lord, the Chief Justice, for the beautiful suggestion and enlightening us on the different aspects of JJ Act and POXO Act. We are grateful. May I now request Honorable Mr. Justice Harish Tandon to address on behalf of the Juvenile Justice Committee.
Good morning to everybody. I was not supposed to speak in this session as I was entrusted for giving a concluding remark. But acting as a stepney of the Principal Secretary of the Women and Child Social Welfare Department, because she has to undergo a very urgent surgery today. So I have taken up this responsibility to address this august gathering, and more particularly having a child, the psychology keeping in my mind, and also speaking like a child before all of you. Today's program, which has been organized at the state level, is really a precursor for a national consultation program, which is supposed to be held in the next month at Delhi. When we received the information that there will be a national consultation programs focusing on this CCL, the child in conflict with law, and the real focus which appears to the committee of the Supreme Court was how to divert. The diversion was one of the key issues in that consultation program. To that, what I feel is that the question of prevention that comes first before we think about the protection. Unless we prevent the offense to happen, the protection we have to think as a secondary measures. So prevention is also one of the very important facets of the entire symposium. And that is why we have divided 4 topics into 4 business or technical sessions. So that all of you who have been tirelessly working on this particular aspect relating to child, at least we can have some kind of an output, or as the Honorable Chief Justice said, the ideas, sometimes innovative, sometimes well thought of, and sometimes the government should also think about bringing it into a statutory framework. So these are all the motive of the consultation programs to be held at the High Court level. I have some ideas on these topics, and I wanted to highlight those so that I can keep the business session open to ponder upon by all of you to do it. As we all know that the JJ Act was initially in place in 1985. Later on, there was an amendment repealed. Another act came of 2000. Then again repealed, it came in 2015. Why there was a frequent and I would say recurring feature of repealing the earlier act and then bringing the new one is definitely because the government later on thought that the provisions which were there was not adequate enough to deal with these children. And the 2015 Act, I would always feel is a radical change that has come in so far as the child justice or just child-oriented justice is concerned. The main focus of this particular act is not to institutionalize the children, and that should always be regarded as a last resort. Now, the child who has come in conflict with law, whether the diversion is the best method which can be implemented, thought of, instead of a conventional way of retributive justice as we know in a system. I have some views on this, which I gathered from different research papers and also my ideas, which I want to just place before you. The enactment of Juvenile Justice Act is a milestone in itself, as it laid emphasis on reformation and reintegration of a child in conflict with law back into the society, which symbolizes that the society has come to understand that the psychology and the ability of the child to make informed decision is completely different from that of an adult. And therefore, it would be unreasonable to place the child and an adult on an equal pedestal. With procedural loopholes in the systems coming in forefront in the recent times, pre-adjudications, diversion is a better option to tackle social stigmatization and the risk of recidivism by focusing on providing individualized treatment, and the encourages community participation in helping the child to unlearn delinquent behavior and eliminate the negative impact of institutionalization. The diverse programs are tailored to suit the special need of the juvenile delinquent by taking into account the socio-economic variables. The diversion is not a process which seeks to undermine the constitutional rights of a child. Rather, it seeks to avoid the unnecessary imposition of the social control over the child and assist in realizing his innate potentials and accommodating to the established social norms. My suggestion in this regard would be to form a peer group of children of a same age group, instead of exposing them with the CCL, committing a heinous crime or a CNCP to eradicate any exposition or gaining experience of a technique or skill having a negative impact of committing a repeated crime. Children's home must be equipped with the adequate infrastructure to segregate the CCL committing petty crime, serious crime, and a heinous crime. That is based on Rule 29 of the Model Rules 2016. Before implementing the judicial diversion programs in the Indian context, as we know that all these the notion of bringing those Juvenile Justice Act that came really from the UN Charter, to which the India ratifies. And sometimes what I feel is that there are so much of researches which has come in the perspective of the European cultures, in the perspective of the US cultures, is the perspective of a extreme, the southeast part of the globe. But so far as the Indian perspective is concerned, we have to think in that line. And the borrowing those notions with the lock, stock, and barrel, I think that would not suit the children who have a different cultures, who have a different way of life, and a different society to which we live. So this diversion program, one has to understand in this regard that the lawmakers have to keep in mind that our criminal justice system is based on a established procedure of law as we gather it from the Constitution model, which upholds the constitutional rights of the accused religiously, and in keeping with this, they need to ensure such programs are fitted within well-defined ambits of the Indian Constitution. The concept of juvenile justice system has come to a full circle in the sense that the juvenile courts are established to divert the children from an adult criminal justice system, and even efforts are made to completely divert children from the entire court system through juvenile diversion programs. Diversion programs would prove beneficial in reforming the children as well as adolescents whose behavior do not cross the threshold of amounting to an act involving moral turpitude, but whether such programs would have a positive impact on delinquents of 16 years of age or above, who are now a separate category altogether, is worth giving a thought and working towards. We owe it to the future generations, the youth, to provide them a world in which there are endless opportunities for them to explore and choose their path so that they can make a mark and leave their legacy behind. The juvenile's diversion is one of the big steps in this direction. So far as the court procedures are concerned, so the juvenile court, which is also recognized as a children's court, established to handle the problems of delinquent, neglected or abused children, it is sine qua non to accomplish the proceeding of a court informally so that the juvenile can be treated in a cozy and the child accustomed way. Under this juvenile justice law and the provisions of the criminal court procedure, children are not to be taken to a regular criminal courts. The purpose of separate court is a social legal rehabilitation and reinformation instead of retributive justice. When a juveniles are found to be below the age of 18 years, he will be tried in a juvenile justice board. When the CCL is between the age of 16 to 18 and have committed a heinous crime as mentioned under the Juvenile Justice Act of 2015, he will be tried by the Children's Court as an adult. I find that the Children's Court are defined in the Act, but so far as these cases concerning the heinous crime by a children between the age of 16 and 18, the definition itself says that the Court of Session can act as a children's court. But in my view, I appeal to all of you to think about whether that would be the proper way of dealing those children as well. Because when the Act talks about a children's court, it may be that the session court may act as a children's court. Do we not need a separate children's court to set up? And the children's, the atmosphere, the congenial atmospheres compatible to the child's psychology, that should be provided therein. So this is what the government has to think of to establish a children's court in every district. Obviously, we are working on that, and we are trying to collate the data of the number of cases which are pending before the Court of Session, where the child has committed a heinous crime and is between the age of 16 and 18. If there is an adequate number of cases, then the two things that really require to be thought about. One is why there is a spurt of cases which is coming. Secondly, from which district it is really coming so that we can combat the situations, we can make an awareness, we can do a very extensive programs in those districts just to curb those kind of offense to have been committed there. And if there is number of cases suggests establishment of a specialized or designated children's court under the JJ Act, then at least when the government is here, my request to them to think about and then establish a children's court under the JJ Act to deal with those cases between the same. So far as the assessment of those children who have committed the heinous crime, it is the most arduous task of the board to make a preliminary assessment of a child committing the heinous crime, more particularly relating to his mental and physical capacity, not only to commit an offense, but to understand the consequence to such offense, which should not be confused with the established principle of trial. There should not be. It should not be done in this way. The legislators, because everywhere there is a check and balances and the corrections have to be made. So in this act also, the legislators being conscious of an error in the preliminary assessment by the board that a child has committed a heinous crime and should be tried as an adult, empowers the children's court to take a decision as to whether there is any need for trial of a child as an adult under the criminal procedure, and therefore the preliminary assessment by the board cannot be regarded as a sacrosanct. This is the second check and balances which the Act says regarding, because we do not want that the child should suffer for any error which has been committed. So far as a prevention, there are a lot of ideas which everybody gets. Now we are globally connected with the technologies. So I have picked up some and I wanted to say something more on this. The practice of diversion and the minimum institutionalization as a principal aim have been positive outcomes as far as the rehabilitation is concerned. In order to prevent, first step is identification of such juveniles, and then providing them with the required treatment is of utmost importance. These adolescents become habitual offenders if not timely stopped by the committing offenses. Most effective way to prevent the juvenile delinquency has indubitably been to assess the children and their family from the very beginning. We have a lot of programs so far as the psychological support, the mental support given to the children who have come in conflict with law. What I feel is that the family or the parent should also be counseled in this regard, so that at least they are the first responder to the child when they nurture the child in the home, so that at least they can inculcate those senses that what would be the serious outcome they would suffer because of this. The state programs attempt at a very interventions, allowing numerous groups to tackle the problems in a number of ways. And the most effective measures which I gathered was the active role of the parents, as I said, and the state as a custodian of the child's fundamental right. These are the two principles we have to bear in mind so to prevent the recurrence of this child. As the Honorable Chairperson of the Juvenile Justice Committee also talked about the Article 21A of the Constitution regarding their rights. So I do not want to deliberate much thereupon. The second focus which I really wanted all of you to come up and suggest is how we can do a fair trial in a very child-friendly atmosphere. On the last occasion, if I remember, we presented that how we are doing, how the court procedures are being conducted at the national consultations. And that has been accepted by all the participants therein, that how we have created a child-friendly atmospheres in every, the districts, mostly in every district. In some of the subdivisions, we have also created a child-friendly court. And this is what I feel is that we have to come up, think like a child, think about the best, what we can do for them. Nobody wants to come in conflict with law. It's either a circumstances or the compulsion. Sometimes it may be a social, economical, the variables which has come may put them into a conflict with law. How we can deal with that. And in the concluding, I say that in the developing world, there may be many factors that can affect the growth of a child. They are adversely affected by a changing conditions. To address the juvenile delinquency, it is important to adopt a comprehensive approach which focuses on the prevention, early interventions, and the rehabilitations. And I end with the quote of Dr. APJ Kalam, the former president of the country, that let us sacrifice our today so that our children can have a better tomorrow. Thank you. Jai Hind.
Thank you, Lordship, for your constant guidance. We are ever grateful to your Lordship. May I now request Mrs. Nandini Paliwal, Commissioner cum Principal Secretary, Department of Social Welfare, Andaman and Nicobar Island, to address on virtual mode.
Honorable Chief Justice, Sri T.S. Sibgyan of the High Court of Calcutta and Patron-in-Chief, Juvenile Justice Committee, Honorable Justice Sri Indra Prasanna Mukherjee, Chairperson, Juvenile Justice Committee, Honorable Justice Sri Harish Tandon, Member, Juvenile Justice Committee, all other honorable judges of the High Court of Calcutta, dignitaries and participants in the state-level multi-stakeholder consultation on child in conflict with law being held in the city of Joy, Kolkata. A very good morning to all of you from Andaman Nicobar Islands. I am joined today by my colleagues Pallavi Sarkar, Secretary Social Welfare, Nitin Shakya, Director Social Welfare, and Srimati Rita Devi, Welfare Officer. At the outset, I would like to extend my sincere thanks to the Honorable Juvenile Justice Committee of the Calcutta High Court and the West Bengal Judicial Academy for providing me an opportunity to address such an august gathering. I would like to present today an overview of the scenario of juvenile justice and child rights in Andaman and Nicobar Islands, with special focus on children in conflict with law. William Wordsworth said, "The child is the father of the man," which means that the behavior and activities of a person's childhood go a long way in building his personality. In line with this philosophy, this UT administration envisages to secure a healthy and happy childhood for every child in this UT. We all believe children are born guiltless, and it is the society which should take responsibility to bring up a good human being and enable them to discover their full potential. Thus, the outline of the future human society is determined by the mental and physical well-being of the children the society has brought up. With this aim in mind, the UT of Nicobar Islands has a well-organized setup at the Union Territory, district, as well as at the grassroots level to achieve the overall growth and welfare of children in need of protection and for children in conflict with law. The State Protection Society, the State Child Protection Society, the State Adoption Resource Agency, the Child Welfare Committees, and Juvenile Justice Boards of all the 3 districts here have been made functional and are running. The progress of these committees is reviewed at the highest level by the state level monitoring and review committee headed by the Chief Secretary for convergence of various line departments for implementation of Mission Vatsalya. The state level Child Welfare and Protection Committee under Mission Vatsalya has also been notified, and the district level committees are in the process of being notified. There are 3 district child protection units which have been rendering services under the overall supervision of the deputy commissioners in all the 3 districts of the Union Territory. There are 11 childcare institutions in the island, out of which 4 are government-run homes and 7 are NGO-run homes, all funded under the Mission Vatsalya scheme. A total of 316 children are registered, and at present, 256 children are staying in these childcare institutions. The Department of Social Welfare, which is the nodal department for child welfare, is maintaining 1 observation cum special home for children in conflict with law. All legislations in favor of the children, the Juvenile Justice, Care and Protection of Children Act 2015, the Protection of Children from Sexual Offences Act 2012, the Prohibition of Child Marriage Act and Right to Education Act are being implemented by the UT administration. The UT administration has also recently drafted the Juvenile Justice Amendment Rules as per the amendment made by the Government of India in the year 2022. We have around 57 child welfare officers designated in 21 police stations in various districts, functioning under the 4 special juvenile police units of the police department. The CID, or the Crime Investigation Department, is the nodal unit for these SJPUs, and SPCID acts as the nodal officer for Andaman and Nicobar Police at the UT level. At the district level, district SSPs are the nodal officers for the concerned districts. All the police personnel have undergone legal as well as sensitization training, hopefully equipping them to deal with children in conflict with law in a more sensitive fashion. On an assessment done of the juvenile delinquency cases over the last 5 years, it has been found that the major causal agents are broken family ties, illiteracy, poverty, drinking habits and drug abuse of family members, adolescent instability and impulses, poor recreational facilities, excessive exposure sometimes to media, particularly social media, and peer group, which drives the children towards violation of law. In majority of these cases, children often lack an outlet to their emotions and proper guidance at home or in their academic institutions. The department, in its endeavor to ensure the welfare of delinquent juveniles, is providing counseling to children lodged in the observations home. And also, family counseling is being provided to ensure all-round development and educational support both to the children as well as to the parents. Juveniles are encouraged to understand the harm they have caused to themselves and to take responsibility. Focus is on towards utilizing their energies and innate curiosity towards productive ends to make them responsible and contributing citizens of the country. In a heart-warming result, I would like to share with the August members here that 5 children from our girls' home are working in various capacities in the government departments of Andaman and Nicobar Islands, including one in our own district child protection unit. Quarterly excursions to nearby tourist places, including screening of movies of national integration, movies with social messages, are also being held for all children, and administration is also trying to increase the frequency of such activities. Inter-CCI sports competition and sports day held for children belonging to all CCIs have also given them an exposure of the world and a chance to interact with other children similarly placed. Police entertainment teams have also been roped in to conduct cultural programs in all CCIs to bridge the gap that sometimes exists between the law enforcement agencies and the children in need of protection of law. And at the same time, this acts as a source of edutainment and motivation for the children as well as for the police officials. Joining hands with the Directorate of Employment, our department has also started career counseling sessions in the presence of psychologists for the children at our homes starting this month. Computer labs are also being set up in government CCIs with the help of CSR funds roped in from various agencies so that children gain computer literacy and have access to a more competitive world. Beauty administration is committed in working to better the situation when it comes to juvenile crime. Although the extent of juvenile crime in Andamans is not widespread, there are still certain issues that require the active cooperation of the larger society to prevent the juveniles from committing any crime. We recognize the need for continuous dialogue between all the different wings of government, judiciary, civil society, and advocacy groups for further strengthening the ecosystem of juvenile care and making it more sensitive and responsive to the needs of the future citizens of our country. We look forward to a very productive session of consultation and guidance from this esteemed group of members attending the program. 6 representatives from the Andaman and Nicobar Island administration are present in Kolkata today to take part physically in the subsequent discussions and consultations that have been planned for today. We hope that this endeavor will help us in reintegrating children in conflict with law with the society. Thank you so much.
Thank you, madam, for joining with us and participating in this state-level consultation. Thanks you once again. May I now request Mr. Mohammad Mahiuddin, Chief UNICEF Office for West Bengal, to address.
Honorable Chief Justice T.S. Shivagnanam, Calcutta High Court and Patron-in-Chief, Juvenile Justice Committee, Honorable Justice I.P. Mukherjee, Chairperson, Juvenile Justice Committee, Calcutta High Court, Honorable Justice Harish Tandon, Member of the Juvenile Justice Committee, Principal Secretary, Department of Women and Child Development and Social Welfare, Andaman and Nicobar Island, Director, Child Rights and Trafficking, representing the Department of Women and Child Development, Government of West Bengal, Honorable Judges of the Calcutta High Court, members of the Judicial Service, government officials from different departments, NGO representatives and caregivers from across West Bengal and Andaman and Nicobar Islands. A very good morning to all. At first, I sincerely thank all of you for your tremendous work for this consultation today. While discussing the principles of diversion for children in conflict with law under the Juvenile Justice Act 2015, it's important to look at the global principles and guidelines such as United Nations Convention on the Rights of Child, commonly known as UNCRC, the United Nations Standard Minimum Rules of Administration for Juvenile Justice, commonly referred as the Beijing Rules, and the United Nations Standard Minimum Rules for Non-Custodial Measures, commonly referred as Tokyo Rules. We are happy to note here that as a UN representative, that India, the principle of diversion and family-based alternative care spelled out in the Juvenile Justice Act is fully aligned with all those international convention guidelines and rules. First and foremost, and according to the UNCRC, the best interest of the child should be paramount importance, and that it should be upheld always in all decisions and actions concerning every child, even if the child is in conflict with law. Number two, all efforts to prevent the child from offending should be the primary strategy, as it is in the best interest of the child and cost effective. Number three, at the same time, it is needless to mention about the need and importance to have a child-friendly justice system in place, be it child-friendly police stations, child-friendly courts, child-friendly statutory bodies like the Jajabis, and the child-friendly courts treating both the child in need of care and protection and the child in conflict with law with equal sensitivity. The Beijing Rule reinforces the need for a well-functioning, effective, and efficient diversion program that enables to reduce use of unnecessary detention of children, thereby preventing exposure of children to further harm and exploitation. Both UNCRC and the Beijing rules have clearly indicated that diversion with effective case management and alternatives to detention contributes towards the prevention of reoffending of children in conflict with law and their successful reintegration into the society. Talking about alternatives to detention, and as stated by the Tokyo rules, it is important that diversion programs are community-based, allowing children to stay with their communities and families, whether under care of biological families or under kinship care, wherever it is possible. This enables the community to feel responsible and provide necessary support towards the social reintegration of the child. Last but not least, our experience from the ground has provided that the insight that effective case management and oversight mechanisms are key requisites for successful reintegration of children in conflict with law, in their families, in compliance to national and international standards, and by sharing good practices and experiences about alternatives to detention for children in conflict with law. UNICEF looks towards your leadership and guidance and input today for this workshop to build this initiative for the well-being of children through their integration. We will continue to support this initiative and look forward to its uniform practice across the state. I hope the frequently asked questions document released today will be a critical tool for the practitioners, and your inputs today to further enrich the document in future will be highly important towards the welfare of the children in conflict with law. I extend my best wishes to all participants of today's workshop for enriching and successful consultation today. Finally, I thank the leadership of the Judicial Academy for hosting this event. Thank you very much.
Thank you, sir, for active participation. And the UNICEF always be with us in every occasion and any program. Now it is the time to end the inaugural session. All the participants are requested to go their specified classrooms according to their respective groups for group discussion. We will be back here again at 1 p.m. for the next session. A very good afternoon to all. We have assembled here again for valedictory session. It is the time for presentation of the outcome of group discussion. But Honorable Justice Mousumi Bhattacharya, Member Juvenile Justice Committee and Executive Chairperson, State Legal Services Authority, Andaman or Nicobar Islands, have joined with us, and we have the honor and opportunity to felicitate her ladyship by potted plant and painting. May I now request Sonamoni, a child from Sukonna home, to felicitate her ladyship. ঠিক আছে বলবো না চলে ইয়েস ইয়েস Group 1, Preservation of Child Offending. The speaker is Saurabh Bhattacharya, Judge Special Poxo Court, Howrah. I would like to calm him.
Good afternoon, Namaskar. Regards my Honorable Chief Justice and other Honorable Judges and other respected dignitaries. Our topic is prevention of child offending. Now, it is well said that it is easier to build strong children than to repair broken men. Prevention, there are three pyramids. Advocacy brief on child justice, prevention of children at risk from coming in conflict with the law, tertiary and reactive prevention, secondary or specific prevention, primary or general prevention. Now, there are certain steps we have been asked to concentrate our presentation on two aspects. One is community engagement activities, initiatives, and second is enlisting role of key stakeholders. Now, identifying vulnerable pockets in the community and to try and zero in on children who are at risk. There are three aspects: individual factors, family factors, mental health factors. Next is identifying drivers or stakeholders and their roles, community engagement, youth participation, peer groups, family counseling, educational institutions, schools, prevention program, role of NGOs, local self-government, mass media, particularly social media, integrated approach. Here comes the role of SLSA, DLSA through orientation awareness program in schools, through TV and social media, visiting the CCIs regularly. Next comes the role of DCPU, child protection committees for reporting cases, school awareness programs, need assessment in the community, identification of school dropouts and working with them, child in street situations. Next come the roles of NGO, engagement of children, street situation, vocational training, working with at-risk children in the community, youth participation, DWCD, vocational training, life skill education, sponsorship, foster care, linking them with social security schemes, placement and job security, and the main issues are that we have to identify the gaps and way forward. Inclusion of family therapy in preventive programs, timely intervention on cases of drugs, additional infrastructure for running de-addiction programs, decriminalization of status offenses, adopting multi-dimensional approach in family therapy, alternative placement including foster care. Now, what are the causes of offending behavior in children? We have identified certain few issues like lack of education, faults in upbringing due to unhealthy socio-cultural environment, mental health factors, psychological issues, family factors, neglect or absence of proper parental supervision, substance abuse factors, child exploitation, child labor, peer influence. During our discussion on drafting this presentation, we have identified that these offenses actually needs to be prevented at pre-offense stage and post-offense stage. So the mechanism techniques are also different at the pre-offense stage and the post-offense stage. Now solutions through community engagements, education, recreational activities, prenatal, infancy, in home visitation by nurses, parent-child integration training program, family counseling, youth sheltering, substance abuse education, sex education, involve children in voluntary activities like helping elderly in nursing homes, community programs like clean the neighborhood, plant trees, etc., locality development, social planning, and social action. Bullying in prevention program, community mobilization holds the promise of investing every local resident in solving what is truly a shared goal, to help young people grow up to maximize their potential and reduce the likelihood of involvement in violence and delinquency. Now, while identifying the risk factors for delinquency, we have discussed the role of schools and community. We have considered a history of abuse, look for antisocial and inhibited behavior in young kids, check for signs of hyperactivity, study the kids' home and family environment, find out who their friends are, look into the kids' school performance, intervene with at-risk parents early and often, encourage kids to speak with their parents, make shared activities for parents and kids available, child-parent swimming lessons and art activities, look for a supportive family members, set up the child in a mentoring program, prevent bullying in schools, engage participation in school-sanctioned activities, establish community activities for kids, park, dance, yoga, art classes, encourage kids to participate in community development, designate a spot on community boards for a youth representative, or set up a youth committee responsible for coming up with ideas to include and serve youth in the community. Now here, the role of DLSA and the SLSA not only confines to the awareness program and orientation program. We have discussed the key issues like presently the juvenile child in conflict with law above the age of 14 years, we are getting so many cases of elopement issues. That is a very key issue. Sensitization, awareness, not only amongst the child, amongst the family members are also necessary. Family factors may be inclusive of ongoing family feuds, neglect and abuse or absence of proper parental supervision. We have used the expression that lack of positive parenting is one of the vital issues for this sort of rise in child in conflict with law cases. Another key issue is the drug abuse factors. Now, if we summarize that, we have to first make the prevention, then the treatment, early intervention, and rehabilitation. We have to make a cycle of all these key issues. For this, we require individual program as well as collective program. The role of police is sine qua non in this case. One issue we have also discussed that if we can start the system of mediation at the police station level, then also it can minimize certain sort of family feuds and other social factors issues also. Next is constant watch by police, engagement of children with different activities, sports activities be increased among the children, doctors may go to school to educate them, to create awareness. Now, on conclusions, we have chosen the following steps may be taken to address this core issue. There is an identification of the problem. Next, to customize it, because there are some places where there may be offense of petty case, some places where there may be offense of pickpocketing, some places where there may be offense of drug abuse. So we have to identify the problem, then customize it, then can provide the solutions. We can not have a general solutions. We have to first identify, then customize it, then can provide a general solutions to the particular issues. Then the mental health issues to be addressed, gap between aspirations, role, and need to be addressed, behavioral management to be inculcated, positive parenting to be encouraged, and early intervention of the issue, community-based activities, these are the steps which can be taken to curb this problem. Lordships, I am deeply obliged.
Thank you, Mr. Bhattacharya. Our next speaker from Group B, R.C. Hasnath, Principal Magistrate, Uttar Dinajpur.
Is it okay now? A very good afternoon to all of you, our respected lordships. And here I would like to start my presentation. So we are going to talk about rehabilitation. And we see that rehabilitation is a process and it takes time. And rehabilitation and reintegration should go hand in hand. And it should be individualized and based on the interest. When a CCL is found to have committed a crime, we see that the condition and circumstances in which they have committed the crime leads to the offense. And so we see in cases that their physical appearance and their mental capacity should be taken into consideration while sentencing them. So we see that what are the rehabilitative measures that can also be there in spite of those that have been mentioned in section 18. We thought that why we could not give them a chance to be placed as a civic volunteer in police, where they can be help to the society in general, and they can also, if they work better, they can be rehabilitated afterwards. We also thought that if we see that the CCL who have come before us, if they have a dance interest, why can't we place them in a dance academy and order them to learn dance and to instruct them? Also, we can see, we should see the interest that they have, and we should try to focus on the rehabilitative sentence that can help them to further rehabilitate themselves after that the sentence is even over. We also saw that we can engage them in community services, and the JGB is present in the state of West Bengal. We are already ordering such sentences, like ordering them to take part in midday meals, serving water there, and planting trees. We are already trying to implement these provisions. Using the sponsorship provisions under JJ Act a little more rigorously will help the children in conflict with law, because most of them we see that when they are from lower socioeconomic status, and we don't see that a well-to-do child commits a crime. In most of the cases we see that they belong to poor families and they need support, they need economic support even after that they have been sentenced. So we thought about sponsorship provisions, use of sponsorship provision a bit more, and taking into consideration the education of the child in conflict with law. We also thought about linkages with government family strengthening schemes, developing individual care plan and follow-up. We have suggested that ICP should be different for CCL, those who are in childcare institutions, and for those once they are released from childcare institutions, because they may undergo a reform, and after that, there may be a need for change in the individual care plan. We also saw that follow mechanism is a challenge, especially after the child is released on bail. We also discussed that in case of heinous crimes, Section 18 is not applicable, and Section 19, subsection 2, individual care plan is applicable and should be used. after the child attains 21, if that can transform from retributive to restorative. That means when a heinous crime is committed by a child, he is tried as an adult. But we suggested that in that case we are being too retributive with the child, and we should be concerned about his reformative aspect. We also discussed that in case the child is released from CCI, de-addiction of the child becomes difficult. In case the child doesn't stay for a fortnight in a CCI, ICP cannot be implemented. There are gender bias by families, shielding children who committed sexual offenses, biases against girl children, and in many cases, the communities are resistant to CCL. So admission to schools become challenging. Though we JJBs, at the time of giving bail, we make it assured that the child goes to school. We assure that a school register is being presented to us so that we can assure that even in case we have given bail, the child is attending the school regularly. Immediate age proof is required in cases where the CCL is apprehended at the borderline age and in the case of victims. Because in most of the cases, when the investigating agency refer it to the regular courts, and afterwards a child is found to be a child when his age proof certificate is produced, for that period we see that the rights of the child is being infringed, and he is being detained in regular jails. So that needs to be changed, we suggest. We also suggest that reservation for foster care, knowing the background of the child. There may be incidents of further abuse and exploitation. We have also suggested that individual care plan to be drawn up before social investigation report. There can be linkages with government social protection schemes, and working more closely with the family and the community and the family counseling, because at the end of the day, the CCL has to return to the family. So we see that the counseling of the family is very, very important. Drug abuse prevention program at the district level should be there. Setting up de-addiction centers at the district hospital. Integration with National Tobacco Control Program running by Health Department. We also suggested that JJB and CWC should work together, because even after that we have pronounced a sentence and the rehabilitation process has taken place, even in those cases sometimes the child may be a child in need of care and protection. So we see that JJB and CWC should work together. Assigning PLVs and support persons per child for hand-holding of the child through the process and following up after the child is released. We discussed that there are support persons in POXO cases, but those are not there in JJBs. So we need someone who could be a support person and upon whom the child can put his confidence into. So we also need identification and sensitizations of PLVs. We need dedicated resource pool for hand-holding the child through the process and bridging the gap between the child and the system. We need SOP for rehabilitation to be developed. We also suggested that parental counseling is mandatory, and it cannot be avoided at all, because ultimately family is the social unit, is the smallest social unit, and we must focus upon it. Child-centric health intervention, training of doctors, implementing principle of diversion for rehabilitation. Also, we saw, and as I've already discussed, that all JJBs are ordering for sending children to school. Memorandum of Understanding between Directorate of Child Rights and Trafficking and NIOS, that is open school. So even in cases when the child is unable to go back to the school, we can focus on their education by giving them access to open school. Specific skills training for children in each district in collaboration with Technical Education Department. Also, convergence between CWC and JJB. Also, we suggested that there should be celebration of birthdays in childcare institutions. That should be a welcome step, and I think it should be done. It would at least, we all have the right to celebrate our birthdays, and even they should not be denied that. Thank you. That's all.
Thank you, madam. Next speaker is from Group C, Gargi Banerjee, Program Manager, Prajok.
So in our group, we were discussing about the different issues concerning the children in conflict with law. So registering of, as in diversion, we were discussing that registering of GD only for cases of petty and serious offenses. Yes, the group was of the opinion that this process has started, but it needs to catch up because in many situations, FIRs are being done and they are being forwarded, the children are being then produced before the JJB. So this led us to discuss that when the case is coming to the JJB, the petty offense case, are we able to dispose of the case in the first hearing? So that also has its own challenge because once the case comes with an FIR, it needs adequate amount of hearings. There has to be, like, the prosecution has to be given a chance. So disposing the case at the very first hearing often becomes a challenge unless and until there are adequate evidences, papers, etc., which enables the principal magistrate to dispose of the case. And along with disposing of the case, when we were discussing the ICP is a challenge because in many cases, the matters get over so fast that there's no scope of giving an ICP, and also, like, who would follow up with the ICP? What would be the implementation of the ICP? That was yet another area which we were discussing. Then about transferring CCLs, declaring them as CNCPs and transferring them to CWCs, that do happen. Principal magistrates mentioned that they do declare CCLs as CNCP and transfer them to CWCs, but the cases continue with the JJBs. And instances of, we had public prosecutor sir also with us, where we were discussing that which are the situations when bail is opposed to a CCL, basically when there are issues of safety and security of the child, if the child is led back to the community or to his place. So there, in those cases where the bail is opposed, the child is kept with the CCIs, counseling for regular counseling, and also it was mentioned that local situation report is sought from the police because there was like one case of political violence which was also being discussed. So local situation report are sought from the police to see as to like when that CCL can be released from the CCI to go back. And another very important issue that we were discussing was destruction of records of the CCL after the case is disposed of. This is, principal magistrates definitely do mention this destructions in their orders, but there needs to be a lot of discussion around this as to how this is being done. And there was also a suggestion that if we could have an SOP around this destruction as to what does this mean to not to destroy a record of a CCL child. So another issue which was raised by the police personnel who were there with us was that release and base of CCLs often hamper investigation processes in POCSO cases particularly. So that was yet another challenge which they face. SBR continues remaining a challenge, the social background reports. Challenge as in SBR, it's not that they are not submitted. Everybody agreed to the fact that things are improving, but still a lot of work needs to be done around the SBR, and also the quality of the SBR often remains a concern. I mean, based on that, releasing somebody back to the community, the SBR has a lot of weight. So that needs to be looked into. And another thing, another concern which was raised is that, yes, we are speaking of releasing the CCL back to the community. So once the CCL is going back to the community, who is ensuring and how the counseling process of this child or the whereabouts of this child, the benefit, how the entire ICP, that was the discussion, that without the ICP, this cannot be ensured. And so if there is an ICP, what would be the linkages? Who would be the people who would come into play to ensure that this ICP is being done and the child is mainstreamed largely? And then we had another interesting discussion about termination of proceedings after 6 months if there is an inconclusive inquiry. So according to the JJ Act, there is this 4+2 months thing, 6 months where the cases can be terminated. So here the challenge was, yes, there is the practice where principal magistrates did mention of termination of cases, but the point is that often these terminations are challenged. They are challenged by the other party saying that what was the ground that, I mean, it becomes that is what we were discussing at the end, that it all ends with awareness, that how do you explain to somebody that it is there in my right, because many of these verdicts are then being challenged, these termination of cases. And another thing that we were discussing is that these all could also be, in a way, mitigated if there was a scope of mediation between the victim and the perpetrator at some level in the JJB. Because if there was this scope, even there were magistrates who suggested that if there could be a trained mediator also, like then these scopes of, again, another case being launched against a termination, or these issues might be mitigated to a certain extent. So if that can also be thought of at some point of time. So finally, the way forward, we were thinking as improved and more coordination between police and JJB. Of course, there is, it has started, but it needs to, again, be improved further. Training on diversion with the police, and also the SBR was raised over and over again. There was this thing of sensitization of where, I mean, we mentioned public, but at large, like, because even the principle, because when there is an offense committed by a CCL, it is against someone, so the other person also needs to know that this CCL has some rights in some frame. So otherwise, it becomes like every time it is contested. And then the need to explore the scope of restorative justice, rigorous trainings on documentation, fit facilities for CCL is needed. That was another concern that was raised. And need to have clear guidelines on destruction of records by the JJB, by the police, by the higher courts, or the certified copies which are there at all levels. Thank you. This is me.
Thank you, madam. Our next speaker is Paramita Pal, Principal Magistrate, Purba Medinipur, from Group D.
Honorable Chief Justice of High Court at Calcutta, other honorable judges of the Juvenile Justice Committee of Calcutta, other honorable judges of Calcutta High Court, all the dignitaries present here on the dais and off the dais, a very good afternoon. I'm presenting on behalf of the Group D, and we had the discussion on right to a fair trial and a child-friendly procedures, including legal and other appropriate assistance. So firstly, what we have gathered from our discussion that the key progresses and the actions what we are taking on behalf of the stakeholders for the best interest of the child. So first of all, the District Legal Services Authority in various districts are conducting various legal awareness camps, including the students, the parents, and the judicial, amongst the judicial officers, the public prosecutors, the legal aid service providers, police administrations, and including the paralegal volunteers. When the board works on behalf of the Juvenile Justice Board, I can say, we usually, when we conduct the inquiry against the CCL, we generally keeping in mind regarding the best interest of the child and the situation in which the CCL has committed the offense, rather by whom he was insisting to do the thing. So the difference between the criminal justice system and the juvenile justice system is the main awareness point as we have gathered after this group discussion amongst the society at large. On part of the district legal services authorities, various paralegal volunteers are also given responsibilities to visit various areas to aware regarding the legal aid program so that no CCL can be unrepresented when they are producing before the board after apprehension. Excuse me. The next slide. ফুল স্ক্রিন করে দেখতে পাচ্ছি না নেক্সট স্লাইডটা বলছি During our discussion, some challenges we have gathered. The first and foremost, what we have talked about, the main point, as the POCSO Act is gender neutral, so in case of 363, 365, along with the POCSO, as nominated cases like romantic relationships, they are arising out of, there, what happening actually in the society, the FIR is lodging against the CCL, only the boy. But if the boy has not attained the age of 18 years, so that might be a point of awareness that the parent of the boy also can file a FIR against the child, because we are not aware who is insisting to do the thing or on which point the boy was insisted by the girls or vice versa. The girl is insisted by the boy. So that was the main challenging points in case of romantic relationships along with the POCSO cases, as we are talking about the best interest of the child in regard to the CCL. In between the stakeholders, a good relationship and the communication must be there when we are working as a team here. We are working not against the accused persons, we are working against the CCLs. They are actually the future of a society, and this is a system which actually, the actual goal of this system is to reform the CCLs. So the main communication gaps are actually happening in between the stakeholders of various departments. one of our group member has initiated one point. In some districts, CCLs are remains unrepresented. So they are suggesting for appointment exclusive defense counsel for JJB also. Another point has arisen out of the discussion that after apprehension of the children in conflict with law, there are lacking of proper counseling. The actual rule or fair trial rights or the child rights, what they have during their inquiry process. After the discussion, the suggestions what we have gathered from our discussion that the society must be aware about the speedy inquiry. This is not a trial. There must be a difference between the trial and inquiry. But oftenly we see in the papers also, and even when we are talking with each other, they use the term as speedy trial or something. In case of the CCL, the term will be changed as the speedy inquiry. So the importance of the speedy inquiry must be there in source of awareness in various sectors. Customized training programs for judicial officers, public prosecutors, legal aid service providers, police, paralegal volunteers to be developed. And the preliminary assessment of the CCL who is in between the age of 16 to 18 years and have committed any heinous offense, that must be done within 15 days from the very first day of production and should have complete the preliminary assessment process within 3 months. After having the report from the medical board if necessary or if it's mandatory here. The infrastructural issues we have gathered after our discussion in various boards even, they are basically preferring the VC for the CCLs, not physical production in every day with the homes or the place they are belonging from. But this is not possible until and unless we have the proper infrastructure in every areas. And finally, what demand we have in our discussion in a group, that a proper SOP on the fair trial rule and even the child-friendly procedure, as the child-friendly procedure should include the interactive way, how the child should interact with the proper authority so that they can express themselves, they can freely say in what situation they have involved themselves, rather they have insisted by somebody else. Not only the physical structure of the child-friendly procedure. So we have gathered these things after this discussion. Thank you so much.
Thank you, madam. Now, I would like to request Srimati Nilanjana Dasgupta, Director, Child Rights and Trafficking, to come on the dais for concluding remarks.
Honorable Chief Justice, Calcutta High Court, Honorable Chairperson, Juvenile Justice Committee, and Honorable Members of Juvenile Justice Committee of Calcutta High Court, Honorable Justices of Calcutta High Court and other distinguished guests, Chief from UNICEF and others. Now, I have a difficult task of concluding the sessions. From the very beginning, the tone of the today's program was set by Chairperson, Judicial Justice Committee, and obviously Chief Justice of Calcutta High Court. Chairperson, Juvenile Justice Committee, in his welcome address, actually indicated 3 spheres of Juvenile Justice Act, especially child who are in conflict with law, children who are outside the field of litigation, and punishment for committing offenses against children. Honorable Chief Justice, again, in his keynote address, indicated that every child has an inherent potential. And JJ Act, Juvenile Justice Act is an holistic approach where children in difficult circumstances, how the rights of the children in difficult circumstances can be protected. He also quoted Howard Baker's 4 types of delinquency: individual delinquency, group-supported delinquency, organized delinquency, and situational delinquency. Honorable Justice of Juvenile Justice Committee, Justice Tendon, in his address touched various issues. He started from prevention. The most important thing, he started with the remarks that we should think as a child. In his address, he pointed out that prevention must come first. Important facts of JJ Act, he narrated the important facts also, and institutionalization as a last resort. Proper diversion, he emphasized on the diversions, emphasized on peer group, and keeping the children segregated as petty offense, serious offense, and heinous offense in the childcare institutions. Perspective of the different guidelines should be on our socio-economic perspective. He also emphasized on that. And in the address of UNICEF chief, he pointed out some global perspectives, global principles. He mentioned the Beijing rule and the Tokyo rule in connection with UN standards, and which are already incorporated in our juvenile justice rule. Now, different groups have different tasks, and they presented their discussions in a very nice and very articulated way. The first group, whose topic was prevention, basically, prevention of child offending. In their discussion, they pointed out especially awareness, prevention. Their discussion was initiated with the point of awareness of different stakeholders, school sensitizations, community engagement, different initiatives already taken by police, that is a rapport building between police and the children, vocational training, life skill educations, social security schemes, he pointed out, and ultimately placement. The gaps identified by the groups are definitely very important. That is in family therapy, in absence of family therapy in the preventive programs, lack of timely intervention in case of substance abuse, very little or very less rehabilitation centers or de-addiction centers, decriminalization of status offenses, multidimensional approach in family therapy, and lastly, alternative placement, including foster care. He also pointed out the roles of DLSA and SLSA, not only in the awareness building, but also in different awareness, not only the awareness building of the community, but different stakeholders, including family, some positive parenting and measures against drug abuse is very important. In the presentation of Group B, whose topic was rehabilitation and restorative practice, they emphasized on the fact that rehabilitation is a process and it should be an individualized process and it takes time. It is an individualized process. They mentioned the Section 18 of Juvenile Justice Act, community services, sponsorship as a scope of alternative, as a scope to address the poverty, because most of the CCL comes from a very lower strata of the lower economic strata. Education is a very important. linkage with family strengthening scheme. In follow-up, in case of challenges, they mentioned few that when the CCL is released from the CCI, then follow-up mechanism is a real challenge. In case of also addiction is really an issue. That is also a challenge if the child is being released from the CCI. De-addiction programs, counseling, community is often resistant to accept that child. Continuation of education, though the principal magistrates are mentioning in their order that they also monitoring the school registers, but it's still a challenge. The representative of this group also mentioned the need of immediate age proof. And foster care may be an alternative way to rehabilitate the child. Linkage with different social protection schemes are also important. Other important thing is that JJB and CWC should work together. 2-3 things the representative of this group also mentioned, that assigning a PLV or a support person in the JJB may be a solution, and identification and sensitization of these PLVs. SOP for rehabilitation, child-centric health intervention, sensitization of our doctors. She mentioned some few initiatives taken by our department, like our department has signed an MOU with NIOS so that the children who are out of education can continue their education in open schooling. Skill training of the children with the help of technical education department, not only skill training and then placement in some employment sectors. Celebration of birthday, she also mentioned, it's a very good steps. Next come the third group, whose topic was diversion alternative to detention and non-custodial alternatives. In this group, the representative of the groups actually mentioned few issues like registering of GD only for petty and serious offense, though it is mentioned in the Act, but it is not always happening. The group has posed a question that when a FIR is lodged in a petty offense, then how a JJB can dispose it in the first hearing, because it is a challenge to them. ICP is a challenge because of short duration of the cases, of the stay of the CCL in the CCI, Child Care Institute, is for a very short duration. Follow-up, it's a challenge because who will do the follow-up and who will implement that ICP? CCL and CNCP, this passage, this declaration of a CCL as CNCP is happening. Many of the CCLs are declared as CNCP, but the cases continues. The learned PPs presented in the group, they pointed out that bail is opposed when it is against the safety and security of the child. Local situation report, which is a very important report, it's really, even it's a challenge. They also, suggested that there should be an SOP for destruction of reports. Though it is mentioned in the Act, but there should be an elaborate SOP on destruction of reports. SBR is again a challenge. That means SBR, quality of SBR is again a challenge that requires very rigorous training on SBRs. Again, when the child is back to community, then ensuring counseling and other interventions, which is again that the earlier group also mentioned it as a challenge, and this group also. Termination of proceedings in 6 months in absence of evidence. Often this is a challenge. Scope of, they mentioned a point that scope of mediation at JJB may be, with the presence of a mediator, may solve many such petty cases and serious offense cases. In the way forward, they mentioned that more coordination between police and JJB is required. Training on diversion, SBR, documentations are required. Sensitization of community is very important. Fit facility may be an alternative solution, and clear guideline on destruction. In the group 4, they mention some importance of legal awareness camps. Mention the difference. There is a difference. Awareness. The topic of the awareness should be the awareness. Why the awareness is required? Because criminal justice system and juvenile justice system are different. Community should be aware of that. Workforce development is an important issue. Challenges they mentioned is that in the romantic relationship, due to lack of awareness, often the boy is victimized. Often the boy is termed as CCL. Child-friendly communication. To learn child-friendly communication of all the stakeholders is very important. She mentioned that the entire juvenile justice system works as a team, so everyone should know the child-friendly communication. Guidelines on different aspects or do's and don'ts should be clearly spelled out. Often, CCLs are not represented. So, if a defense counsel, exclusive defense counsel for JJB can be done, that may be a solution. Suggestion of the groups are trial and inquiry, speedy inquiry, customized training program for each and every stakeholders. Preliminary assessment should be completed within a stipulated time, and infrastructural issues, especially the video conferencing facilities, has to be revisited, and proper SOP on fair trial rule and child-friendly approaches may be drafted. Thank you, sir.
Thank you, madam. We would like to specially thanks to Nilanjana madam for her kind cooperation. Without her active assistance, this consultation would not have been successfully organized. May I now humbly request Honorable Justice Mousumi Bhattacharya for vote of thanks.
A very good afternoon to all of you, the Honorable the Chief Justice, all my very esteemed colleagues, and those who are present. I will promise not to keep your vote of thanks beyond 5 minutes. I keep it keep it as short and pithy as possible. I don't have much to say, but thank you first of all, my Chief Justice, Justice I.P. Mukherjee and Justice Tandon, for keeping it at a day and a time so that I could come and join for a brief point, but for a brief period of time, but very productive. I was hearing Mr. Shourav Bhattacharya, Ms. Hasmat, Ms. Gargi Banerjee, and Ms. Parumita Pal, who rounded up these sessions. Extremely informative, productive, and just points which we need to ponder about and do something about, like SOP, like ending everything, the procedure without delay within 3 to 6 months, if that's possible, despite the challenges notwithstanding. Then an ICP, I think Ms. Banerjee, ICP meant Integrated Child Protection Scheme? Individuals? Individual care plan. Thank you for that clarity. I was clarification. I was thinking what it was. Then very important, Ms. Hasmat, what she mentioned was movement from retribution to reformation, to rehabilitation. As we all know, that rehabilitation must be effective, must be meaningful, not that we are doing you a favor, not that we are condescending to bring you into the mainstream, but something which is empowering. So rehabilitation must really be empowerment. Otherwise, it's no real rehabilitation at all. And family, role of family, family therapy, that's extremely important. SOP, another point which is very close to our hearts, our Chief Justice, very close to his interest, that's how to make a use of virtual platforms in order to bring justice to children in conflict with law. That is extremely important, how to prevent them from coming to court every day. We know that West Bengal has porous borders, whether it's Bangladesh, whether it's other countries, Burma, and one of our pressing problems is children, even when trial has ended, for, in some cases, 11 years, 13 years, they are still languishing in India, in West Bengal, without being sent back to their parents' homes. I mean, nothing can be really more heartbreaking, heart-wrenching than this. So these are pressing issues. And really, I mean, child in conflict with law, it's got a definition under Section 213 of the 2015 Act. The sad part is that child in need of care and protection, CNCP, slips down to the next level, down the ladder, to being a child in conflict with law. And it's easy for us to say that, the child has slipped and now is in collision with the law, but we really lack an effective mechanism to bring a child up, one step up the ladder, from a CCL to a CNCP. So we really need to have to, think. And after all, this is justice with kid gloves. I mean, that's a wishful pun. But really, where law does not protect or does not have those effective mechanisms, the law becomes loco parentis, where the child is concerned, because that is something which we really need to be kind of, sensitized to deal with children. So my vote of thanks is, that's about it. And yes, I just remembered, I was thinking about it, Supreme Court in a recent decision, I think that's Narayan Chetanram Chaudhary, that's of 2023, three-judge bench authored by Justice Bose, but I think it was Justice K.M. Joseph and Justice Rishikesh Roy were also there, three-member bench. Section 94 of the 2015 Act, determination of age. In that case, the Supreme Court relied on the school certificate, the board certificate, to determine whether the child, the juvenile in that case, falls below the age of culpability. Then there's an earlier case, I think that's Shilpa Mittal versus NCR Delhi, that's of 2020, which again goes into this whole question of determination, whether a child is a child, whether a child is a juvenile, whether a child is not a child but an adult. Section 94, extremely important, then Section 9(1). So these are just questions which are important for us, for pondering, for bringing back, taking back with us to our respective homes and courts and trying to do something about it. So thank you very much, honorable judges, my Chief Justice, my esteemed colleagues, all of you, Ms. Dashgupta, for a wonderful summing up. That made my work half, a lot easier, because I was not personally present in the inaugural session. All those of you from the districts, from the district judiciary who are here, you're really the foot soldiers. You're really the people who are working at the ground, and we are completely dependent on you to bring and to implement those mechanisms in place. So thank you, and I will hopefully be able to lead you all to lunch and to a happy ending, and really privileged to be part of this. Thank you very much.
Thank you, Lordship. Now we have come to the end of the program. I would now like to seek permission of the Honorable the Chief Justice to conclude the program with National Anthem.
जनगण मन अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंध गुजरात मराठा द्राविड उत्कल बंगा विंध्य हिमाचल यमुना गंगा उच्चल जलधि तरंगा तव शुभ नामे जागे तव शुभ आशीष मांगे गाहे तव जय गाथा जन गण मंगलदायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे